they've taken a number of points about specific performance in the skeleton argument, which you can correct. I heard what the Lordship had to say, and that's really what I prefer to take instructions about trying to get it dealt with now. I mean, if you're in my favour on the points about specific performance in the skeleton, and it's inevitable that there will...
Sorry, if I was in favour of what?
In my favour on the points I raise in relation to specific performance, then it's inevitable that there would have to be a further hearing. And what I wanted to do, the Lordship was kind enough to give me the time to try and decide how best to deal with them. I don't abandon those points because there is a problem about the variation to the contract. And my concern, if I may raise it with you, my Lord, is if one goes to the order that is being sought, which is at page 329 of the bundle. Three to eight, I beg your pardon. It's really, I've dealt with B and the extent to whether that declaration arises, and if so, how much, which is dealt with in three. But there is, I do have want to raise some points really about 1A, because the interest itself is the interest as it was at the 4th of December 2008. But there was, as you know, my Lord, a variation to the head contract, if I can call it that, the tripartite agreement. Just give you the references, if I may, without asking you to turn them up. They're EAT, Bundle 3.1, EAT 4849. And then the addendum itself, which was the Bundle 3.2, E21 5686. I'll just make the point here, my Lord, that the trial clearly proceeded on the basis that that document had been executed. But we've been unable to locate a final executed copy of that document. And the curiosity, my Lord, is that when one gets to the SPA, which I will take you to very briefly, in Bundle 2, this is behind tab C, 29, oblique stroke 29, oblique stroke 236.
I'm so sorry. Bundle
C29 T44 is the paragraph I want to look at. But this is the SPA itself, my Lord.
Sorry, I'm not understanding your reference. Where Bundle 2, divided D.
C, my Lord.
Oh, C, is that right? Yeah.
The document itself starts on page 236.
Yeah, I've got it.
And 244.
Yeah.
By May and June, the purchase price shown in the SPA was still exactly the same as it was before there had been the reduction of 50%. So at that stage it was showing 613,466. The purchase price being payable of 613,466 and 158, of which 72 million you can see was the premium as it was described. Now, my learned friends, when they opened their case, sorry, by the time they came to closing submissions, and this is in Bundle 4, page 249, was saying that the purchase price had been reduced from 691 million, bottom of page 249, paragraph 140, to 381 million. 309 million plus 72 million. And as far as I can see, well, that price was certainly never agreed between the parties, and I don't understand how they got to it. It isn't reflected in the SPA, and it isn't simply a totting up, doesn't involve simply a totting up of the amounts that they are actually paid, plus the liabilities of, if any, to NBC. So there doesn't seem to have been, although there was an agreement, as my learned friend Mr. Flynn records in his skeleton argument, and did record that degree of trial, there's an agreement that we wouldn't be able to claw back any reduction in premium. Doesn't ever seem to have been a final price agreed in relation to the contract once it was amended. That's the first point I make about second.
Well, I'm not sure the point was ever investigated, but I'm assuming it. And they divided 691 by 2.
Well, if that's right, then we may still owe them money if they're continuing to contend that this was the contract price, this was the reduced contract price, then they would be contending that we still owed them money because we haven't paid 381 million, and we haven't, even if we assume the liabilities to Tully, they wouldn't necessarily reach that figure. So we just simply the point we raised, my Lord, and it may be that it's easy for my learned friends to deal with, is that there is an uncertainty about the final terms of the contract. And if you're with me that it was simply a contract to transfer, there are normally the general sorts of considerations. So that's an uncertainty. Normally, if one were to enforce to order specific performance of the contract, one would expect the terms to be absolutely clear. And as you say, my Lord, the actual terms, once amended, were never really investigated. I mean, what is it are the terms of this contract? Is it that we simply assume the liabilities to NBC? Is it we pay a price? And it's a general submission about the difficulty of enforcing or locating all the terms of this contract as it was worked through between the 4th of December 2008 and by the time we reached May 2009 and the anticipated execution of the SPA. So we have a general submission which we explore in our discussion arguments about the difficulties of certainty and enforcement. Secondly, we make the point is that neither party, either at the trial or indeed for today, has investigated the position of AMNAC Finance. And normally, again, one would expect there's to be an order for specific performance made, that it would be critical to establish what their position was. I mean, we submit a slight air of unreality in the order that they're seeking, that we acquire an interest, when that interest is dependent on the behaviour and position of third parties. And if you were to accept my submissions in relation to the question about whether specific performance should be investigated at a subsequent hearing, we would wish to argue the question of the validity of the Murabaha agreement. The reason why I took you in such, perhaps in more detail, perhaps it was warranted to the terms of the Sharia principles, is to show you the issue that arises in relation to the enforcement of the terms. Now, this is a pure issue of law. The facts are clear, my Lord, which one can see in really from NBC's opening submissions, if one goes to page 100 of their skeleton argument, page 99. Sorry, their opening submissions, which are in bundle 4.
Page
99. You'll see it's described as the backdated Murabaha Agreement. And if one goes back to page 96, see 1, 2, 3, on the 18th of September 2008, Dar al-Sharia returned with further guidance as to the mechanics of the transaction and advised as follows. Looking at the authority for a Wakala agreement of them. And then on the 29th of September 2008, Mr. Subi sent Mr. Kapoor the draft Murabaha and promised to purchase. He also described the structure of the transaction as set out above. The Murabaha was signed during October 2008. Mr. Kapoor suggested it was signed on or around 21st October, and Mr. Subi agreed. Now, the significance of that award is that the asset had already been acquired by that date. And it is fundamental to a Murabaha agreement that there should be a sale and purchase by the vendor. And I've quoted extensively in my skeleton argument in the relevant principles. My learned friend, Mr. Kennel, contests that. He says it's not valid. It's not void, it's valid. But there is a question over the validity for non-compliance with those provisions. Now, I heard what my learned friends had to say about the concession made by Mr. Knowles at the trial of the on liability. I would apply to your Lordship to withdraw that concession and to argue the point at any subsequent hearings. Now, this only arises if we go a long way down the track. You may find it possible to resolve all the issues today, and that it's unnecessary for a further hearing. You may reject my arguments in relation to specific performance. It's only if it becomes necessary to have a further hearing after you've heard what my learned friends have to say, particularly on the question of the quantum of the liabilities. If there is a live issue that has to be resolved as a further hearing, then it will be at that point that I would ask to withdraw the concession. You were not determining in my submission what the scope of the liabilities were at the first trial. This issue just simply didn't arise, you might say. And it's not a case where, in my submission, like the decision of Mrs. Justice Gloucester's, where a fundamental point was being made about causation, which should have been made at the first trial. And if I just give you perhaps an example rather than seek to re-argue the law, which is that this one might have a trial, domestic mortgage perhaps, or a commercial mortgage, where you have a question which has to be determined by the court whether which borrowers are liable under the terms of the guarantee, whether they've charged their house to the bank. So you might have a question about whether there had been, say, undue influence, or whether the terms of the guarantee were binding. And the court would be asked to determine this. But in my submission, that wouldn't prevent the borrower taking issues about the validity or invalidity of, let's say, the charge document in subsequent proceedings for possession or payment. That's the analogy I asked you to draw in this case. What you have decided, if you decide against me on the first point, is simply that the liabilities have been assumed by my client JR to NBC. That is now a binding commercial arrangement. But the enforcement in terms or scope of that arrangement could be fought out elsewhere. And there's no reason why, once you've made that decision, JR shouldn't be entitled to raise any points in answer to the claim by NPC. It's not a necessary part of the findings on liability in my submission that we should be prevented from raising this point at a later stage. Your Lordship has my submissions in detail on that. I accept what my learned friends say about the width of the concession. I'm not going to ask you to construe the concession narrowly, but I do say that I am entitled to ask you to allow me to withdraw the concession and to argue what is a simple point of view. And I think that's all I have to say, my Lord. I will endeavour to produce a short schedule over showing you the actual figures over a shorter journey.
Thank you very much. Yes.
My Lord, Mr. Cameron's agreed that I'll go first. My Lord, yesterday Mr. Leach's submissions were superficially beguiling. He said to your Lordship that they were simply seeking clarification in accordance with Justice Giles' indication. I hope your Lordship remembers that. That was what he said. He was not advancing any new points, and it was, at the very least, unreasonable of me to suggest that simply seeking clarification of your Lordship's judgment was abusive. Now, there might be some force in that, if it in any way reflected their case, or indeed our case. What he also said was, whilst it was regrettable that clarification was not sought before applying for permission to appeal, this wasn't my learned friend's fault, it was simply an unfortunate consequence of the conduct of the previous lawyers. And your Lordship would be well aware that no doubt another unfortunate consequence is if he loses on his points today will be an application for permission to appeal to your Lordship, followed by a paper application to the Court of Appeal, followed by an oral renewal of that application in circumstances where it is already 12 months since the trial. What he also showed your Lordship yesterday was a case in which says that your Lordship can change your mind at any time before the order is sealed, although they're not asking your Lordship to change his mind, but they are asking for an order that the premium be returned to them and we pay the costs of the trial. And effectively what my learned friend's submissions are is that the trial we had last year was a trial of a preliminary issue on liability, on some issues of liability. Now, Lord, it will be necessary to unpack the application as it is now made, and it is something of a moving target. I do need to show your Lordship why that clarification application analysis is wrong, but if your Lordship is with us on reading of the judgment as a whole, rather than focusing exclusively on paragraph 98, which has been done time and again, what's been said by my learned friend is, oh, you can't read that in paragraph 98. This isn't apparent from paragraph 98. You have to read the judgment as a whole. And if your Lordship does read the judgment as a whole, as we say your Lordship should, there is nowhere for Dayar to go so far as my clients are concerned. They say they are not raising any new points. And that's right, because they couldn't raise new points, because if they do raise new points, they're bound by issue estoppel or Henderson and Henderson estoppel. Now, implicit in what they say is, well, they could have done a better or a different job at trial than Mr. Knowles. Mr. Knowles did not take a lot of the technical points which are now being taken. Dayar's case at trial was that they were either going to win on the points they did take, and that is essentially those two key points. Was there an agreement? And if there was, should it be set aside? And what cannot be done in my submission is to re-argue the case and claim that the points they're now taking are open to them when they weren't pursued at trial. And what my learned friend says, I think he said this morning, that if your Lordship was with us, then he understood he wouldn't go any further, but it was open to him in the alternative to challenge quantum. And that, he suggested, must be uncontroversial. Can I just remind your Lordship of what that actually means. If you go to bundle 4 at tab 329, sorry, page 329, what that really means in practice is paragraph 3 of the order. Because your Lordship was quite right to point out that there have been calculations. Now, those calculations don't affect, in my submission, my client. They are a matter between NBC and DEAR. So I won't tread on Mr. Kennell's submissions in relation to that, other than to say that the calculations follow from the, or at least arguably follow, the findings on liability. And that's the scope of the debate. It doesn't affect my client at all, because my client is either in or out. If the figures in 3 are adjusted for whatever reason, and there are genuine points of quantification only, which do not amount to a collateral attack on your Lordship's judgment, it doesn't affect my client. Because on my submission, my client gets the declarations that it's entitled to in paragraphs 1 and 2. So I think it's important to have that in mind, because we do accept that my learned friend can argue pure quantification questions, but what he cannot do is reopen liability findings as they're apparent from the judgment. So I do want to show your Lordship next how the position in relation to Justice Giles arose. If you go to, in bundle 4 back to 327, you'll see, if you start at 326, at paragraph 49, this is the paper refusal of permission to appeal by Justice Giles. And you'll see at 49, this ground is simply that the trial judge erred in failing to consider issues 5 and 6 of the agreed list of issues. If your Lordship just turns back to 289, if your Lordship goes back to 289, I don't think you've looked at 289 before, but 289 is the agreed list of issues for the trial. It's an important document because it defines the issues that your Lordship was deciding.
Yeah, we have looked at it.
Yeah, and your Lordship's seen it, 289, and then over the page at 290, under the heading DEAR and NBC, so this is an issue as between DEAR and NBC. If the answer to issue 1 is yes, i.e. whether they entered into a legally binding agreement, was there an ovation or an assignment to DEAR of Talim's obligation to repay NBC? In neither case did that enable NBC to sue DEAR. And if the answer to issue 1 and 5A is that DEAR did not acquire Talim's obligation to repay NBC pursuant to an ovation assignment, did DEAR and NBC otherwise reach any binding legal agreement in relation to Sky Gardens or its financing, and if so, what agreement? Now again, what didn't happen, if it was said that your Lordship's reasoning wasn't clear, or that further reasons were needed, the appropriate course would have been to apply to your Lordship, and that wasn't done. And your Lordship knows that the procedure by which you apply for permission to appeal is an ex parte one. So when you look at the Justice Giles's reasoning, it's really contained in paragraph 52. The trial judge's conclusion that a contract of sale or at least transfer was concluded in December 2008, and there was a concluded agreement for transfer of Talim's interest in Sky Gardens to DEAR on the 4th of December 2008, does not spell out the position as between DEAR and NBC. There are a number of references in the reasons to that position. For example, an email from NBC on the 20th of October 2008 recording the structure of the transaction deals with DEAR's acquisition of Talim's interest in Sky Gardens, and also its undertaking the financial obligation to NBC, and an addendum to the tripartite agreement was prepared apparently involving NBC's finance. Nonetheless, the position as between DEAR and NBC is not made clear in the reasons. and to that extent I accept the ground voices a valid complaint. He then goes on to say, the consequence is not leave to appeal. As with ground 3, Dayar's obligations towards NBC will be stated in the orders yet to be made. Nothing has been done towards making them. If the parties cannot agree on translating the trial judge's reasons into presumably declarations as to whether Talim or Dayar is liable to repay the 200 million to NBC, and that's, my lord, important because that's the issue that he's directing this to, whether it is Talim or Dayar who's liable to repay to NBC, and otherwise the financial obligations between the parties. The trial judge can be asked to resolve their dispute in settling the orders. That is the proper avenue to appeal. What Justice Giles was saying, and paraphrasing him, the judgment was clear as to what happened to the interest in Sky Gardens. The position between Dayar and NBC was not spelt out. So in other words, that's about whether Talim's obligations to national bonds were transferred. Now, as this was an ex parte procedure, we would suggest that the judge's attention was not drawn to the passages in the judgment which we rely on today as establishing that the obligations were transferred. Most notably of all, the judge, Justice Giles, doesn't mention the finding in paragraph 89 of your Lordship's judgment that Dayar recognised its responsibility in lieu of Talim to make the payments. And we submit that if he had had that drawn to his attention properly, he wouldn't have reached the conclusions that he did in paragraphs 52 and 53. And we would also suggest he didn't have firmly in mind the threshold question which your Lordship set out in paragraph 76 of the judgment, which was, it included the question of whether Talim's obligations, including Talim's obligations to repay NBC in respect of the financing it had provided to Talim to purchase its interest in the property. So in other words, what your Lordship was saying is those two issues were being decided together. And that is not because of some alleged failure to recognise that there were two relationships that were being transferred, one under the tripartite agreement and the other in respect of financing. The reason for that, my lord, is because it was Dayar's defence to each of them. It was essentially the same defence. It was that there was no binding agreement, and if there was, it should be set aside. So there can be absolutely no criticism of your Lordship in structuring and wording the judgment in the way that your Lordship does, because it followed from the way in which Dayar advanced its defence to the claims. So in fact, although Justice Giles did say that, and that is a hook on which Dayar could have mounted a limited application to seek only the clarification that Justice Giles identified. But in fact, we would say on a fair reading of the judgment, Justice Giles was in fact wrong. There was nothing unclear and nothing which actually needed clarification.
Is the application for leave in the Bible?
I don't believe so, because I've looked for it myself and I can't find that. All that it has is the grounds, which your Lordship, which are not very illuminating. I'll show you. If you go to 317, the grounds on this issue are paragraph 15 at 317, and what they say is the learned judge erred in failing to consider issues 5 and 6 of the agreed list of issues, and that's it in the grounds. But what we'll try to do, my lord, is dig out over the shorter German the
I'd
more
like to see the
fleshed out version. So we do submit that the key issue that Justice Giles was adverting to there has been decided by your Lordship. And if that is the case, that is, so far as my clients are concerned, that is an end of the application. My learned friend says that what he's seeking is clarification of that. That's the purpose of the application, and we submit that your Lordship has indeed, on a fair reading of the judgment, clarified that position. But the reality is, my learned friend is in fact seeking to do far more than simply having that matter clarified. And we do say that he is trying to advance an all-out attack on the judgment. If you read his, which your Lordship has, his very lengthy note and even longer submissions, throughout those documents are new points, none of which were ever advanced at trial. Your Lordship asked about one. Your Lordship pointed out in relation to the case that national bonds didn't consent to the novation of Toulouse obligations. That hadn't been argued. And when your Lordship pointed out, my learned friend seemed happy to accept that. But that applies to it applies to all of the other points that he's taken, because they're all new points. None of the points they raise were advanced by Dayar at trial. Nothing whatsoever was said about formalities. Nothing was said about consent from AMLAC and DIFC investments. Dayar raised the Sharia points in expert evidence and then backed away from them, as your Lordship saw yesterday. It was never said that the contract became unenforceable because the interest in the property was reduced in April 2009. Now, in my submission, they are all plainly new points, and they're not entitled to advance them. Now, in his skeleton, he seeks to justify introducing new points on the basis of pleading points, and your Lordship has heard quite a lot about the pleading points. And if I just could show you my learned friend's skeleton, just give you three examples. If your Lordship goes to 4.6, does your Lordship have it at page 6?
Yes.
Dayar submits it was not appropriate for the court to make a finding that there was an immediate assignment by Talim to Dayar of Talim's equitable interest in Sky Gardens on the 4th of December 2008 for the following reasons. Firstly, it formed no part of Talim's pleaded case that it assigned its equitable interest under the express trust of Sky Gardens to Dayar on the 4th of December 2008 under Article 90 or 1b. Then, if you go on to 4.8.1, 4.8 on the following page, under the Murabaha agreement, Dayar submits it was not appropriate for the court to make a finding that there was an assignment by Talim to Dayar of its obligations under the Murabaha agreement or any other loan agreement on the 4th of December for the following reasons. 4.8.1, again, it was no part of Talim's pleaded case or its case at trial that had delegated its obligations to Dayar under Article 94.2 of the contract law on the 4th of December 2008. Finally, 5.1, under specific performance. There was no claim by Talim for specific performance in the claim form and particulars of claim. He said a claim for specific performance was advanced in the alternative in Talim's opening submissions. That application has not been pursued at this hearing, but if an application is now made for specific performance, Dayar will submit that the court should not grant specific performance of the agreement for the reasons there set out. So, my Lord, those are all points which are done by reference to the pleadings. And if my learned friend is genuinely not raising new points, then in my submission you can't pursue those points today. And I'm afraid, my Lord, I will have to take you to the pleadings. I was hoping I could avoid it, but I will take your Lordship in a moment to those. But I do want to make also one thing clear, that my learned friend said yesterday that our position was that it was an abuse to come back to your Lordship for clarification at all. He was saying that it was unreasonable for us to suggest it's abusive to do that, when it's clear that Justice Giles invited them to do so, and indeed that was the proper course. That is manifestly not our position and never has been. If all he were doing were coming back before your Lordship and asking for clarification of that one point, it would be a very different situation. Albeit our case is that no clarification is required, because when you read the judgment as a whole, the position is very clear. But that is not what he's doing. He is raising a whole raft of new points, and it is that which is abusive. Those points were never canvassed at trial. And we say it's precluded from raising them both as a result of issue estoppel or Henderson and notice in the stock board. So I will just quickly, as quickly as I can, because they are raised and they're not abandoned, and they are in my friend's written document, the pleading points, just to show your lordship what the position actually is on the pleading. If you go to bundle 1, and you take the particulars of claim first of all, go to paragraph 25 first, at page 7.
Give me a page reference.
Sorry, page 7, my lord. So A127, it's
Yeah.
paragraph 25. Thus, by an agreed process of novation arranged by NBC, Daya acquired the interest in the property and became liable to NBC for 2 payments of 81 million dirham made by NBC in respect of the sums due to ASG to first Dubai on the 15th of September and the 15th of November 2008. Entries recording this fact were made in the accounts of both NBC and Daya. Now, at that stage, it was unclear exactly what NBC's demand included, but we do suggest that throughout the pleading, it's quite clear that Talim's case was that Daya had acquired Talim's interest in the property. And I won't take your lordship to detail of it, but it's from paragraph 16 to 26 that we set out the thrust of that submission. But if your lordship does go on to page 11, your lordship will see the relief sought, paragraph 35b, which is a declaration that Talim and Daya concluded a transaction with NBC whereby the 33% interest in the property at Sky Gardens was transferred along with associated financing obligations, and so Talim is entitled to retain an agreed premium of 72 million odd paid by Daya on the 4th of December 2008 by cheque. Now, if your lordship then goes on to page 13, your lordship will seek the claimant's response to a request by the first defendant, National Bonds, for further information. And if your lordship looks at paragraph 3.1 on page 13, your lordship will see that it said Talim's interest in the property and liability in international bonds were transferred to Daya by a process of novation, alternatively assignment, as a result of the matters set out in A2F. And your lordship will see so if your lordship goes on to 144, same tab, that is the claimant's reply and defence to Daya's counterclaim. And there we summarise Talim's case. If your lordship sees, does your lordship have it? Page 144, paragraph 3. Talim's case in summary is that Talim transferred its interest in the property to Daya and or Talim, and Daya agreed to transfer that interest to Daya. In exchange, Talim transferred to Daya any and all obligations it had towards NBC and or Daya, agreed to assume all such liabilities, and Daya paid to Talim and or agreed to pay a premium in the sum of 72 million odd dirham. Now, the same pleading was in the reply. If your lordship goes to back to page 129, this is the claimant's reply and defence to NBC's counterclaim, and your lordship will see it's in exactly the same terms as paragraph 3. So well, it's very difficult to see how it can be suggested that wasn't pleaded. But the other point, while we're in the pleadings, what Daya also say is that specific performance wasn't pleaded. It was. If your lordship goes first of all to page 145, to the reply and defence to counterclaim, you'll see in paragraph 7, accordingly, Talim seeks as against Dayar the declarations claimed in paragraph 35 of the 6th claim which your Lordship saw, and B, an order requiring Dayar to complete the transaction and assume Talim's rights and liabilities in respect of Sky Gardens, including any liability Talim may have towards NBC. So, although it's fair to say that the word specific performance are not used, that is the substance of the relief which is sought. If your Lordship goes back going on to page 173 in this bundle, just right towards the end of the tab, your Lordship will see this is the agreed list of issues prepared originally, and your Lordship will see at paragraphs 32 to 34 the remedies sought by Talim. Is Talim entitled to a declaration that Dayar has assumed Talim's rights and obligations in respect of Sky Gardens? If Dayar has not assumed Talim's rights and obligations in respect of Sky Gardens, is Dayar in breach of contract for failing to do so? Is Talim entitled to an order requiring Dayar to do so? Just to can I next ask your Lordship to go to bundle 4? At page 49, and this is our opening for the trial, and it's 284 to 286. Your Lordship will see. If under the heading Remedies, which is on page 48, if the court finds there was an agreement to transfer but that no transfer took place, then Dayar is in breach of the agreement. Talim seeks in the first instance specific performance of the agreement. Then we cite the law, 285, Article 39 of the Law of Damages and Remedies states the court may order one party to a contract to perform its contracted obligations, so long as the obligation is specific and or the subject matter of the obligation is specific, and the court decides that damages are unquantifiable or not a sufficient remedy. 286, the transaction relates to an interest in land. The vendor of land would not normally be entitled to an order for specific, would normally be entitled to an order for specific performance. All the other parties to the tripartite and the financing arrangements consent to the transaction. Dayar is not obliged to perform it. Talim will be faced with liabilities it is unable to meet. So it's absolutely clear that was raised, and just to finish it off, just to put it beyond all doubt, it was also dealt with in the oral opening, which is in bundle 2 at the T tab, day 1, page 62. Will see it's me speaking from page 55, but lines 5 to 8, if there was an agreement to transfer, but in fact no transfer, we seek specific performance or damages. As I've said, if you seek damages, they don't need to be assessed at this stage. So just that makes 2 points. One is, clearly we're asking for specific performance, but so far as quantification was concerned, it was more a question of our damages, and particularly if your Lordship found that there was no agreement. But my Lord, short point is, it can be absolutely no basis for suggesting that this was not pleaded, not raised, not fairly and squarely an issue at the trial. I should just show you one last document, which is the rejoinder, and in a sense I'm only showing it to your Lordship because it doesn't say anything at all. It's in bundle 1, page 164. only showing this to your lordship because it's the rejoinder of DAR, but it doesn't say anything at all about specific performance or engage with the issue. The short point, my lord, is twofold. One is the suggestion that these were not matters either pleaded or fairly and squarely in issue at the trial is simply wrong. But the more significant point, in a sense, is why do they need to raise those issues? The reason they need to raise those issues is they need some basis for suggesting to your lordship today that they should be entitled to raise new issues which were not advanced at trial. Now, I see the time, and if it's a convenient moment for your lordship.
We'll take a break. Thank you.
Yes.
Thank you very much. So we can at 2 o'clock.
All right.
I think he's taken all the notes himself.